and I call your name, please say. Please say present or here so I can mark you down on the docket. You got to mute in the lower right. Mr. Atkins is here. Ryan Dancer. Samantha Dowling Wise. Where are you at? Ms. Wise, come on forward and meet with pretrial release, probation department. I'm going to have you drug tested this morning. Shelly Gates. Don't step over that. Don't go around it. Go this way. It's there for a reason. It's not a suggestion. Just come on through. Matthew Gould. Christian Grindell. Jaquavian Jackson. Jaquavian Antron Jackson for Sanctions Court. Caden Mitchell. David Pesnell. Derek Silva. Derek James Silva. I can't hear you. He's not going to be here this morning. He calls for you. Okay. He's Sanctions Court. I'll let y'all deal with him. Royce White. Jason Nichols. Motion for continuance granted, reset to Thursday of this week, March 30th. Shayna Dobie. Shayna Sapien Dobie. I thought I saw Mr. Bratter. She's probably here. I saw Mr. Bratter. Ms. Abraham says she's seen Ms. Dobie. Lisa Peace. Okay. And Ms. Peace is going to enter an appearance. We're going to reset. There's a motion for continuance filed and granted. Pre-trial's been set to May 9th. Mr. Waddell, once you're done with Ms. Peace, if you'll just have her sign a notice of appearance and we'll put a date on that, then she'll be free to go. Okay. Thanks, sir. Brandy Palmer. John Baird. John Lejean. Isaiah Smith. Naomi Escobar. Anthony Collard. Was that moved to 1:30, Mr. Schmidt? Okay. Okay, thanks. J.C. White. Ernest Bowie. Matthew England. Jeremy Estridge. Jeremy Hester. Jeremy Hester. Kirkland Huggins. So that the state's aware, Atlanta Calder was set today on an indigency hearing. That's been removed. Ms. Calder has signed an amendment to her probation to pay the court-appointed indigent fees. So she's been removed. Julie Polans.
I got a text message from her that said she
Christopher Watson.
here.
Cottrell Hickerson. Wendy Price.
Mr. Price's contact office.
Benjamin Miles. William Hayes. Thank you, sir. All right, is there anyone who's in the courtroom and I've not called your name? Everyone's accounted for? All right, counsel, do we have anyone that's ready? Mr. Wood, you ready? Sir. Who are you ready on? Benjamin Ray Miles, CR 22381. Mr. Miles, I'll show set for pretrial. Yeah, Your Honor, we were inspired on this case, brother. Relatively recent, I've had a chance to review the paper discovery, not had a chance to review the, where you have not had a chance to pick up the. Talked to the wife about his mom yesterday. So I guess. Mr. Wood, are you available on Tuesday, April 25th? All right, court sets Mr. Miles for additional pretrial on Tuesday, April 25th at 9 a.m. Thank you, Mr. Wood. Good to see you. Mr. Schmidt, who are you ready on?
Jason White, Your Honor.
Mr. White, if you'll come forward, cause number CR 22298 and CR 22310.
Your Honor,
You may. All right, Mr. White, if you will, sir, raise your right hand and place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. I do. All right, thank you, sir. You can lower. All right, Mr. White, in cause number CR 22310, you are charged with the offense of driving while intoxicated, a Class B misdemeanor. And in cause for CR 22298, you are charged with the third-degree felony offense of evading arrest or detention with a vehicle. Mr. White, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? No. In this case, you're represented by your attorney, Mr. Brian Schmidt. Are you pleased with him as your attorney? I am. Do you feel like you've had enough time to talk with him about your cases and have all of your legal questions answered? Yes. Anything about the paperwork that you've read over and signed today that you do not understand? No, sir. Mr. Schmidt, do you believe your client to be competent today? Yes, Your Honor. And have you explained to him his rights as they pertain to the agreement here regarding the pretrial intervention contract? I have, Your Honor. And have you talked to him about the specific waivers that he's making therein regarding a waiver of a jury trial, waiver of a speedy trial, and a limited right of expunction? Yes, Your Honor. And you believe that he understands all of this? Yes, sir. All right, Mr. White, with regards to CR 22310, a charge of driving while intoxicated, a Class B misdemeanor, the range of punishment for that offense, if convicted and sentenced, could be incarceration in the county jail for up to 180 days and a fine not to exceed $2,000. Do you understand that range of punishment? I do. As part of your plea agreement, it appears that you would plead guilty to that offense in exchange for the state's recommendation that you enter into a pretrial intervention contract for a period of 18 months. Do you understand that the contract will last for 18 months?
Yes.
Do you understand that as part of this contract, you would be making some waivers of some very important rights, and you would be stipulating to the admissibility of evidence that could be used against you in a trial at a later date if you violate this contract? And Mr. White, has anyone threatened, forced, or pressured you to enter into this pretrial intervention contract today? Mr. White, do you understand that by entering into the contract, you would be giving up your right to a trial by a jury? Yes, sir. And when you gave up that right to the trial by jury, you would also be giving up the right to cross-examine the state's witnesses, confront them, and contest the evidence before a jury.
Understand.
You understand that you would also be giving up the right for a speedy trial.
Correct.
And you would also be giving up your right to have any criminal records expunged belonging to the DA's office or the probation department.
Yes, sir.
And Mr. White, I have to ask you, on your waiver of jury trial, you understand that you and only you can waive that right. Mr. Schmidt can't waive it. I can't make you waive it. The state's attorneys can't make you waive that. You understand that?
Understand.
And has anyone threatened you, forced you, or pressured you to make you feel like you had to waive any of these rights today, including your right to a waiver of jury trial?
No, sir.
Mr. Schmidt, do you believe that Mr. White is waiving his right to a jury trial intentionally, knowingly, voluntarily?
Yes, sir.
All right, court will find that Mr. White has been admonished as to his rights to a jury trial, that he has intentionally, knowingly, and voluntarily waived the same. Court finds that the state has agreed to the waiver of jury trial with regards to their case, and that Mr. White has been joined in by counsel Mr. Schmidt. Court is approving the waiver of jury trial. Mr. White, at this time, I would ask you, how do you plead to driving while intoxicated?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No.
The court will accept the defendant's plea of guilt at this time. Anything further from the state? Anything further from the defense? All right, court will take the defendant's plea under advisement. Court will place Mr. White into the court's pretrial intervention contract for a period of 18 months under the terms and conditions of the contract. Court will also dismiss CR 22-298. Is the state asking the court to dismiss that charge today, or to wait to see if Mr. White is going to successfully complete his pretrial intervention?
Judge, I'm actually going to dismiss today. Mr. Schmidt is going to continue with the prosecution.
All right, court will grant the state's motion to dismiss in cause number CR 22-298. All right, Mr. White, court has approved your pretrial intervention contract and it's dismissed cause number CR 22-298. If you'll come forward and meet with the pretrial or the probation officers, they'll give you more information about your contract. Yes, thank you, Mr. Schmidt. Mr. Manning, you ready? Yes, sir. Who are you ready on? Mr. Lejean, if you'll come forward, sir. You may. All right, this is cause number CR 21-402, State versus John William Lejean Jr. Go ahead, Mr. Manning.
Yes, Judge, as you all, we've been past in John's case, for some medical issues, he had that surgery planned for, it's scheduled for tomorrow, he's done all of his, pre-op stuff and is set that schedule. We have to be set out, for 30 days.
Any objection from the state? Mr. Manning, what about April 27th? All right, and Mr. Manning, as your client, Mr. Lejean entered into a waiver of jury trial today.
Yes, yes, Judge.
All right, Mr. Lejean, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower again. Mr. Lejean, you have signed a waiver of jury trial today. Is that correct? Did you read over this document and talk with your attorney about this? You understand everything that you read and signed? You understand that you and only you can waive your constitutional right to a jury trial? And you understand that once you waive that right may not be restored to you, meaning you don't get to change your mind at a later date. And when you waive your right to a jury trial, you're telling me that you're going to waive your right to contest the state's evidence and confront their witnesses in front of a jury. And that you are, the reason you're doing this is because you want to resolve your case by way of a plea agreement. Is that right? All right. And Mr. Lejean, has anyone threatened, forced, or pressured you to waive your jury trial today? All right, Mr. Manning, you join in with Mr. Lejean in waiving his right to a jury trial.
I did, we discussed, right, somebody who's waiving that, actually, no,
Thank you, sir. State's waiving his right to a jury trial. All right, court finds that Mr. Lejean has been admonished, has intentionally, knowingly, and voluntarily waived his right to a jury trial. Court approves the waiver of jury trial and places Mr. Lejean on the docket for April 27th. Will that be a morning plea or an afternoon plea?
Judge, I didn't think about that, if we can keep it in the morning, provide some additional documentation to the state. And it may not be, yeah.
All right, court sets Mr. Lejean for April 27th at 9 a.m.
Judge, I received, a report from Mr. Fair, and discussed that with both the state and with the probation department, and will be investigating.
Thank you, sir. Good morning, sir.
Eric Quentin, Brady White, Mr. William Hayes.
All right, Mr. Hayes, if you'll come on up, sir. This is cause numbers CR 22-300 and sequentially through 306. Good morning, gentlemen. Go ahead. So we're set for
Yes, Your
docket call.
Yes, Your Honor, we're respectfully requesting that the case be set for another docket call. Your Honor, we believe that we're very close to reaching a bargaining agreement with the district attorney's office. We need to finalize information and then turn it into Ms. Curry. So as soon as she's available, we anticipate being able to reach a plea bargain in this case.
How much time do you need to do that?
Your Honor, we can request to be reset to the first week of May, the jury trial. In April. So if we can be set any day on the first week of May.
State. What about Tuesday, May 9th or Thursday, May 11th?
That works for us.
Which one?
May 9th.
May 9th? All right, Mr. Hayes, you're ordered back before the court for docket call on May 9th at 9 a.m.
Thank you very much.
You're welcome. Once he signs his notice of appearance, then he is free to go.
Thank you.
You're welcome. Good morning, sir. How are you? Doing fine, doing fine.
So when we play Fox,
Esquivel?
okay.
Yes. All right, CR 21-286. Go ahead, Mr. Rieta.
Big Judge, so we are requesting recess so that, these basis for the most indicator cases that are unindicted, and unfiled at this moment. So, guess we need to see if this county is terrible, actually indict or file these cases. Don't have any notification other than that, so the state, I think, has got recent development probation officers haven't reviewed yet, asking for some time. State to review whatever it is that they need, us to contact their stats. This.
Do you know if they're misdemeanors or felonies?
Felonies.
Felonies. What about, do you think that we could have a response from, are you reaching out to Coffee County?
Judge, I actually just request the information. You helped me about it, though. I can reach out to Docket County and find out where they are in the process. Oh, I'm sorry.
It's Terrell County.
County.
Terrell County.
Okay, I thought you said the city of Terrell.
No, it's Terrell, yeah, no, it's Terrell County.
Okay. All right, I can't set it out too far and waiting for another county, so the state may have to decide if they want to go forward on their motion or not, but let's set it for, are you available, Mr. Rueda, on Tuesday, April 25th?
I believe so, Judge. I think that's a problem.
You say that's okay?
That's fine, Judge.
All right, court sets Ms. Esquivel for hearing on motion to revoke. That's a non-contested hearing on April 25th at 9 a.m. Mr. Smith? Isaiah Everett Smith, CR 2279, CR 2282. Show that we're set for plea today, Mr. Massar, is that correct?
We were anticipating it today. We're trying to get some more issues back. May 11th, I think.
Why did the plea fall through for today?
Just there's issues that state money. I'll say it today. I'll say it has a mental issue that he did deal with. Address those mental issues. And it's the May 11th.
State.
Judge, that's correct. Mental health is part of it. Documentation as to Mr. Smith efforts in that area.
All right, court will set Mr. Smith for May 11th at 9 a.m.
Thank you.
You're welcome. Good morning, Mr. Prater. How are you, sir?
Okay, how are you?
We're fine. CR 22-130, CR 22-131, State versus Shayna Sapien Dobie. Docket call, go ahead, Mr. Prater.
Judge, I'm actually gonna take over. Mr. Fratter and I have been in communication quite often. As the court is aware from prior settings, there has been there's a lot of discovery in this case, and there's been some back and forth about what has been made available, what hasn't been. We were able to get together last week and discovered that there was quite a bit that Will's Point believed that they had given us, but the flash drive that we had was associated with another case. They provided us additional flash drive that had, I believe, over 700 crime scene photos and approximately 70 body cam videos. We have provided that to both Mr. Schmidt for the co-defendant and Mr. Fratter this morning in court. We do have one more file that's coming today from Will's Point that's being copied as we speak that Mr. Fratter will be able to pick up. We are waiting for a supplemental report from the Texas Rangers, which I've been assured will be to us by next week. So we do have some outstanding discovery issues. We are very close to having that completed, Lord willing. I think we're all ready to get to that point. But there have been significant updates that I wanted to notify the court of. So given the volume of what we were missing, we had a duplicate file that was the wrong flash drive essentially. State would not be opposed to a 60-day reset because there is quite a bit of newly turned over discovery.
What time frame are you looking for, Mr. Prater?
I think that's reasonable. Your Honor, I mean, we've been slowly getting closer and closer, getting the flash drive already, pick up the other one, today. I mean, of course, willing to push up part of the matter, obviously. 60 to 70 body cam videos, that's a lot of body cam videos, just, so I'm okay with at least 60 days, but of course, we're going to push it out forward. That'd be great.
Are you available on May 25th?
Yes.
All right, court will set Ms. Dobie then for status on discovery on Thursday, May 25th, 9 a.m.
Thank
you. You're welcome. Once she signs her notice of appearance and gets the yellow copy, she's free to go. Morning, Mr. Hugler. I'm feeling fine. Yourself? Randy, Wade, Palmer, CR 22, 386 and 387. Oh, nice. Nice. The gift. Objection from the state? No. All right, court will set Mr. Palmer then for additional pretrial on Tuesday, May 9th. At 9 a.m. You're welcome. Once he signs his notice of appearance, he's free to go. You as well. You're welcome, sir. Good morning, sir. Remind me your name. Karen.
White.
Okay.
310098.
Thank you, sir.
I'm here to make it here.
Yes, I believe that Mr. White, we had him reset so that he could retain an attorney. So it looks like he's done his job. I'm assuming you've been retained. Okay. All right, then let's set Mr. White. Have you had an opportunity to review the indictment in these cases?
I have not got this case yet.
All right, what I'd like to do, State, can you assist the court in printing out the indictments in each one of these cases, providing them to Mr. Herring, and then I'd like to go ahead. Herring, okay. I just had it on here. Thank you, sir. So the state's going to print out the indictments, and then I want you to go over those with your client. Let's go ahead and arraign him today, and then we'll set him for a pretrial. While they're printing that out, let's look at your calendar for a pretrial date.
I think it already been arraigned.
Has he?
Yes, Judge, just to refresh the court, he was on the jury selection docket when his attorney filed a motion to withdraw, which the court granted.
Okay.
Today was just a status on hiring the attorney to put him back on the jury selection docket. However, state is going to ask that we set this for another status. Mr. Herring and I have been in discussions, and we are waiting to get a call back from the victim. I believe that we are very close to reaching a plea agreement on this. And so if we could just keep it on a docket call / status setting, so we're continuing to communicate, it doesn't get lost on the jury trial list.
Okay. Well, thank you for that refresher. I would not have remembered that. All right, so Mr. Herring, I can set this off about 30 or 45 days, give you time to get caught up on the case, continue discussions with the state. I've got some dates. I've got some dates available, either April 25th or May 9th.
So let's get there. 29 days after that.
After that, okay. Let's do May 9th.
Thank you, Ron.
You're welcome, sir.
Be dismissed.
Yes, once he signs his notice of appearance and gets the yellow copy, white copy stays with me, then he'll be free to go. Mr. Schmidt, are you next? Who are you ready on? Ernest Bowie, CR 16232. All right, go ahead, Mr. Schmidt. We can set on the contested docket on April 27th. All right, so court sets Mr. Bowie for contested hearing on April 27th. That'll be at 9 a.m. Free to go. Matthew Virgil England, CR 21356, CR 2312. So that he has a motion to adjudicate and a pretrial. Do you have a certain date or anything, certain time amount you're looking for?
Just on Tuesday.
April 25th. All right, Mr. England, you're ordered back before the court, April 25th at 1:30.
So. Zoom, we have. Zoom tail lines.
Yes, sir.
That's on. That's. Yes.
Correct, yeah. And if he'll just let them know when he gets there, they'll let him. Jeremy Estridge, CR 1119. Mr. Estridge set on motion to revoke, Mr. Schmidt.
Extent.
And are we having monthly compliance with payments? Is he making monthly payments?
Yeah.
How much are you paying, Mr. Estridge?
My normal payment's $1,050. I try to pay at least 13,200.
That's a month. All right, so what I'll do, Mr. Estridge, is I'm gonna set you out, and we have no other issues on compliance, correct? All right, so what I'll do is I'll reset you for, as long as you're making that minimal payment, follow the advice of your attorney, pay more if you can, so you can resolve this issue, but your bare minimum that you ordered, and then I will set you for June. Mr. Schmidt, you available June 27th?
Yes.
Okay. So that's, I'm gonna set you out 3 months, so you're not just coming back here every 30 days, but just because I'm not seeing you every 30 days doesn't mean I'm not checking on you. So I want you to continue to pay and follow the advice of your attorney, okay? All right, court sets Mr. Estridge for status on probation financials on June 27th. Jeremy Hester here. Well, and Mr. Hester, there was a request by the surety to go off bond, and the court did not grant that yesterday. So if Mr. Hester does not appear today, the court's gonna obviously find this bond to be insufficient. Yes, it says Ace Springer, but I was speaking with Cindy Davis yesterday. Mr. White, you ready?
Please, so Your Honor.
You just have Mr. Atkins today, or no, you have, let's do Christopher Watson, CR 22-198. All right, Mr. Watson, set for docket call.
Your Honor, we are going to be asking for one more docket call. Actually, it's probably going to be, I would say 95 to 99% sure. Technically, as much as anything, I want to be able to talk to him about all the potential possibilities that he could have if he went to trial. But under the circumstances, I would be setting this for a plea. Except it's just better set it for a docket because just in case somewhere I miss.
Any objection from state?
No, Your Honor, we've been deep negotiations later.
All right, court will set a final docket call on April 25th. 9 a.m. Is Julie Poland's here. Ms. Poland's, come on up. CR 22-361, State versus Julie Lutz Poland's for docket call. Go ahead, Mr. White.
Your Honor, pretty much the same announcement, but I didn't want to be able to go over with her all the possible ramifications so that she can. In effect, probably take the plea with right one.
Any objection from the state? All right, court sets Ms. Poland's for a final docket call on 4/25, April 25th at 9 a.m. All right, Mr. White, let's see, Mr. Atkins, Come on over and stand with Mr. White. All right, this is cause number CR 22-1, CR 22-236, CR 22-368. And I showed that we were set for pretrial in all cases. Go ahead, Mr. White.
That's correct, Your Honor. We don't have any pretrial that, set for a docket. Anticipating that we will be taking a plea. We have done a lot of negotiations. It's at this point right now, the state is granted me, I guess, 30 days to find an even better alternative than what we are looking at right now. One thing I am concerned about is obviously he was sitting up there. This was he was actually arrested on this charge in court about 2-3 months ago. But at that point, for some reason or another, the sheriff's office could not find him. This is not anything new. Well, they evidently found it, and we have it signed by Judge Action today. We got a recommended bond of $10,000. I was just hoping that we might be able to actually have that set so that you can be able to bond out and go to work today, because there's a lot of people who are interested in him keeping his job.
I mean, he'll need to go to the jail. The warrant has to be executed. He'll have to be magistrated there.
Well, I was hoping that you might be able to set the bond so that you'd be able to go to that party and go ahead and make his job this afternoon.
I mean, the warrant has to be executed. He has to be fingerprinted all over there. The bond's already set by Judge Ashlock, right? At
Well, we
$10,000.
got a recommended.
Well, it's gonna be the magistrate that's gonna have to review. Senate Bill 6 has really changed the landscape on how these things work. And so when he goes to the jail, they have to access the public safety report system, have to review the criminal history.
We do, we're gonna have to go in.
No, I'm saying that the magistrate has to do all of that. So I'd have to stop, access his public report, safety system, review all of his criminal history, go into the system, set the bail. And so I'm assuming that if he's over there this morning, there's probably gonna be a magistrate that's magistrating this morning. We can check to find that out. I don't mind. I wouldn't be the magistrate setting it though. So you have to go through that magistration process, and that magistrate's going to be responsible to report to OCA what bail they set, that they've reviewed the bail factors, and that they have to certify it in their electronic system that gets reported to the state.
Well, it's worth a shot.
I know. If it were that easy, I would do it, but they've really tied our hands on it. So
Yes. That's it.
so let's set him. Is April 25th enough time for the reset?
I think that would be fine.
All right, and Mr. Atkins, you're set for, and you want that for plea, Mr. White?
If we just send it for a docket, I'm fairly certain that we will be able to come up with we've already got a parachute right now. Like I said, we are just trying to see if we can find something, a facility that may be a little bit better for his particular situation.
All right, court sets Mr. Atkins for docket call on April 25th. 9 a.m. if he's out of custody, 1:30 if he's in custody. All right, come on, Mr. Atkins, come on, have a seat. Check. Ryan Dancer, CR 2263. This is the sanctions court hearing. So. He's right there, so. All right, Mr. Dancer, this is a sanctions court hearing. I show at the last hearing, you were ordered to work 50 hours of community service to try to get you caught up. And that the sanction was going to be for every 10 hours that you did not complete, that there was going to be 1 day in jail assessed. My records reflect that as of March 20th, you had not reported or had not worked any community service. Is that true or not true? Can you bring that to me? You have a police report or an insurance report? Did the sheriff's office come out? I mean, did you call them or? And what day did this happen? March 11th. What was our last sanctions court? Mr. Dancer? Are you currently working? Where are you working at? When did you start working there? Did you report any of that or provide proof? No, there is. You're giving this to me today. Did you give it to the probation officers before? Do you know that everything goes through them? So then it comes to me. It doesn't go from me to them. It goes from them to me. So why have you not provided this to them? She said she didn't need it. Yeah, no, I'm just talking about the work. I'm just talking about your pay stub for Long John stuff. So you're telling me that because you didn't have a car, you weren't able to do your community service? Did you go to the doctor or hospital or anything? So you don't have any documentation of getting medical treatment? Are you completely healed now? Yes, sir. So you owe me 50 hours of community service. If I reset you and tell you you owe me 100 hours of community service, are you gonna be able to get it done? Are you working this weekend? All right, this is what we're gonna do, Mr. Dancer. I'm gonna set you for. The May 1st. So that would be 6th. No, in May. All right, Mr. Dancer, I'm gonna set you to come back to court on May 9th. At 9 AM. And I'm gonna order you to specifically work the first Monday community service program. That's 50 hours. I want you to do the whole weekend. I want you to start on Thursday and go through Sunday. You'll get 50 hours. And then I want you to work the next one. So you're gonna work the one at the beginning of the month and you're gonna work the one at the end of the month. That's gonna, that way I know you get 100 hours. All right, so it means if you have to take off and forego the money, you have to take off and forego the money because your liberty should be more important at this point. Okay, so if you'll work Thursday through Sunday, you'll get 100. You'll get 50 hours for each weekend. We'll get you caught up. Okay. And on your job, you need to keep working and provide whatever they ask for. Don't bring it to court. Get it to them before you come to court. What I want to do is when they walk in here and they hand me this little sheet that tells me what you've done and what you haven't done, I want it to say he's done everything. Not, I don't want to have to sit here and go through all your paperwork. I want them to do it because that's their job. And they're going to go through there and they can question you about it. They can figure out what they need, what they don't need. And they can report to me, he's doing well, he's doing fine. Let's take him out of sanctions court. Let's put him back on regular probation. Okay. I don't want to babysit you. Okay. Whatever. Mr. Nolan White, are you ready?
Yes.
You ready on both clients?
Yes, sir, I am.
Cottrell Hickerson, CR 22-105. Mr. Hickerson is set for docket call.
Your Honor, we've submitted, a waiver for attorney trial. She got it. I would represent the court on that, I explained waiver. That one, he's made attorney trial. They. That's.
All right, Mr. Hickerson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Thank you, sir. All right, your name is Cottrell Schmeichel Hickerson, is that correct? And Mr. Hickerson, you have signed a waiver of jury trial today after speaking with your attorney, Mr. White, is that correct?
Yes, sir.
And do you understand that this document indicates that you understand that you have a right to a trial by jury and that you are voluntarily giving up that right so that you can enter into a plea agreement to resolve your case? And do you understand, Mr. Hickerson, that if you waive your right to a jury trial, that right may not be given back to you later in this case?
Yes, sir.
And when you give up your right to a jury trial, you're giving up your right to confront the state's witnesses and their evidence. You're given up the right to call your own witnesses or present your own evidence before a jury. And Mr. Hickerson, are you doing this because this is what you want to do? No one's threatened you, forced you, pressured you, made you feel like you had to waive your right to a jury trial?
No, sir.
All right, court will find that Mr. Hickerson has been admonished as to his right to a jury trial, that he's intentionally, knowingly, and voluntarily waived that right, that he's joined in by counsel, Mr. White, and the court finds that the state has also waived its right to a jury trial. Court will approve the waiver of jury trial. We'll set this matter for plea agreement on May 25th, Mr. White?
Yes, understand. That's first.
Yes, Thursday, May 25th. And will that be a 9 a.m. plea or a 1:30? All right, so plea on May 25th at 9 a.m. Mr. Hickerson, once you sign, get the yellow copy, you're free to go. Are you, is he an out-of-state resident? All right. All right, so Mr. Hickerson, once you sign and get the yellow copy, come over here and see Ms. Burns, and then after you speak with her, you'll be free to go. Wendy Price, CR 22-339. This Price is set for pretrial, Mr. White.
Your Honor, we did file a motion for discovery regarding some evidence spoken. Ms. Highland was going to state a email from the lab over in Howard. They said they would have those documents held by them this week, and may not.
Your Honor, that's correct. I requested back. They took me 60 days. I followed up last week. They emailed me this morning. Next in line. It's via email. They have to pay.
All right, court will reset pretrial for Ms. Price. We'll set next hearing on May 9th at 9 a.m. Yes, he's free to go. Shelley Gates, CR 18397. Gates. All right, this needs to be on the record. This is an extension. This is cause number CR 18397, State versus Shelley and Gates, and this is amendment to the conditions of community supervision, including an extension for a period of 1 year, which would extend the period of community supervision to an end date of April 8th of 2024. I would also include the addition of additional probation fees and your analysis fees during that time period. Ms. Gates, are you wanting to extend your community supervision period? And why you want to do that? Okay. And so you believe if we extend it for an additional 1 year, you'd be able to complete and avoid a revocation? All right. Has anyone threatened, forced, or pressured you to make you feel like you had to extend your probationary period? All right, court will amend the conditions of community supervision for Ms. Gates, ordering an extension of a period of 1 year beginning April 9th, 2023 until April 8th, 2024. The court will amend the probation and your analysis fee conditions to impose additional fees for the duration of that period. All right, Ms. Gates, I've amended your conditions of community supervision. Look over here and see the probation officers. They'll give you some information. You'll be free to go. Matthew Gould. All right, Mr. Gould, this is a sanctions court hearing. This is cause number CR 2389. Mr. Gould, I see that you're getting caught up on the balance that you owe to the counselor. Is that correct? That you're paying $300 a month. I've got a report that you are paying that amount, that you set up a payment plan with the counselor, and that you're complying with that. I show as of about a week ago, you still owed about $761. You believe that if we can continue each month, you'll be able to pay that $300. Okay. All right. So what I'm going to do is I'm going to reset you to May 9th, and it's just going to be another compliance hearing to make sure that you're staying compliant with your payment plan. Okay. All right. Let me give you a notice of setting. All right, Mr. Gold, come on up. Manning, are you ready? Are you ready on? John Larry Baird, CR 22-266. You may. Mr. Manning, are the misdemeanors in my court?
No, just there. If you'd like to. I he was fine signing.
He said he was fine with me signing off. All right, Mr. Baird, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, Mr. Baird, your name is John Larry Baird, is that correct? Mr. Baird, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? Okay, can you tell me what you've been diagnosed with if you know?
You have a bag of everything else there.
Okay, do you feel like you have a rational understanding of what's going on in this case here today?
Yes.
All right. And you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with him as your attorney?
Yes.
Feel like you've had enough time to talk with him about your case and have all of your legal questions answered? And Mr. Baird, is there anything about this paperwork that you've read over and signed today that you do not understand? Mr. Manning, do you believe Mr. Baird to be competent?
I do this.
Have you seen any evidence of anything that would cause you concern regarding his mental health status?
Not today, Judge. As you recall, this case has been said a couple of times. Workly, we had the paperwork, they provide that to us. In situations that we go for, however, say Mr. Baird is here present and able to basically discuss where the consequences discuss situation.
All right, Mr. Baird, you are charged in CR 22-266 with the second-degree felony offense of arson. If convicted and sentenced, a range of punishment for arson is confinement in the Texas Department of Criminal Justice for not less than 2 years or more than 20 years, and also an optional fine not to exceed $10,000. Do you understand that full range of punishment? I see that the plea agreement in your case that you're asking the court to accept is that you would plead guilty to arson. State would be recommending to the court that the court consider the evidence, defer a finding of guilt, meaning that the court take it into consideration but not convict you today, rather to place you on 6 years of community supervision, assess a fine, court costs, reimbursement fees, and dismiss 3 misdemeanor cases as part of the plea. If the court were to follow this plea agreement and place you on probation, if later you violate the terms and conditions of your probation, you can be brought back to court. The court would conduct a hearing. The hearing would not be whether or not you committed the criminal offense of arson. The hearing would be about whether or not you violated the conditions of your community supervision. If the court finds that you violate any of these conditions, the court could do several things, including adjudicate you, which means convict you of the offense. Court could revoke you from probation. The court could sentence you to prison, any amount of time between that minimum 2 years, all the way up to that maximum 20 years in prison. Do you understand that risk? Understanding all that, do you still wish to go forward? All right, and Mr. Manning, you explained to Mr. Baird the advantages and disadvantages of a deferred adjudication plea.
I have
Mr. Baird, then, how do you plead to the second-degree felony offense of arson? Are you pleading guilty to this crime because you are guilty of committing this crime? Has anyone threatened, forced, or pressured you to plead guilty? Court accepts the defendant's plea of guilt at this time. Mr. Manning, any objection to state's evidence?
no objection to this one.
All right, state's one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Yes, Your Honor. Yes, Your Honor. In regards to victim compliance, the state is in victim compliance, we provide a victim impact statement to the victim. Have not received anything back from them. Given my reading of this case, I do believe due to Mr. Merrick's mental illness, this opportunity to receive and seek treatment. That's this.
Mr. Baird is a resident of Texas, is that correct?
He is Judge, he's a resident of Texas, he is appointed to transfer into probation county, it's where he is from living, and it's where he lives in Anderson. And all, so it's. There's a lot of actually, that's the Anderson or just allow him to receive the treatment. he needs.
Thank you, Mr. Manning. Anything further from state? From the defense?
No, Your Honor.
Court's going to review the evidence. Court has reviewed the evidence. Court will follow the plea agreement on the recommendation of the state of Texas. Court hereby defers a finding of guilt, places Mr. Baird on 6 years community supervision, orders him to pay a $1,000 fine, $290 court costs, $540 reimbursement fees. Court dismisses under section 1245, cause numbers 2022-323 criminal trespass, 2022-273 criminal trespass, 2022-274 criminal trespass. Mr. Manning, you said that Mr. Baird would not be residing in the Grants Lane area anymore, correct? You said Wood County? And is there any prohibition with him going back to this neighborhood or wherever he was that where he started the fire? So if he moves back next door to these people, maybe some community outcrop of that. All right, Mr. Baird, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Have you come forward to be fingerprinted with Deputy Everett? After that, you're going to be with the probation department and they'll give you more information. Christian Grindell. All right, Mr. Grindell, this is cause number CR 19177. This is a sanctions court hearing. Let's see, Mr. Grindell, you were ordered to pay $430 to probation. And you complied with that. You paid off all the restitution. That's good. You paid $120 to collections. That just means paid to me. We didn't know anything else in that. The only issue we have, it looks like you had 50 hours of community service. It says that you did 19 of those. What happened on that? All right, so this is what I'm gonna do. I'm gonna have you come back on May 9th. And I want you to have paid your $60 to probation. That's your monthly fee. Your reporting fee, okay? And then, because you took care of your restitution and you paid what you owed to your collections, I'm not gonna hammer you on the community service, okay? But you need to know that you have to work 25 hours every month if you want to expire on time. Okay. Yeah, so you're gonna talk to your probation officer about changing jobs, that's fine. Yeah, talk to them. So I'm gonna reset you to May 9th, and I wanna see you paying your monthly $60 reporting fee. And I wanna see as much community service as you can do. If you get this job and you can knock it out, great. You have a lot of community service you gotta get done. You're set to expire in December of next year, 24. So you've got about 40 hours worked. And so that you still have about a little over 400 hours. So this job may, if it works out, maybe that will be the answer. Maybe it won't. I don't know. But 25 hours a month is what it's going to take in order for you to expire on time in December. Okay. All right, come on forward. We're going to give you a notice of appearance, reset date to May 9th. And then if he's over here, and then if the job works out, then the probation officers will let me know. We may have to make an adjustment to that. Or we may have to even change your state. Okay. Good to go. Wavy and Jackson. CR 21361. It's also Sanctions Court. All right, Mr. Jackson, there were several things that you needed to do. One of them was serve your 3 days in jail. You did that. You failed to pay probation. You failed to pay your court fees. You failed to work community service. You failed to enroll in your drug offender education class. Why did we have so many failures?
And I still didn't find a job, but I have a job. I interviewed tomorrow, but I did the 15 hours of community service.
Did you turn that into your probation officer?
I haven't seen her yet.
Well, you need to have that turned in before you ever come to court. That doesn't mean the day you come to court. That means the Friday before you come to court, because they have to produce these records and they have to verify all of that. So just bringing it to me doesn't comply. Okay. I know that if you're working it, that's good. You need to do that. But the step with compliance is you work it, you give it to your probation officer so they don't write down here that you failed. It would say complied. And if you have more complies than failed, I'm a happy judge. If you have more fails than complies, not a happy judge. Make sense? What about your money?
Most of my money that I do have, because I'm not employed at the moment, most of the money I do have goes towards my rent.
Why didn't you enroll in the drug offender class?
But she said I have to pay for it first.
What county was that in?
Smith,
How much is it?
100 and something, if I'm not mistaken.
So you don't have a job. Are you looking for a job?
Yes, sir. I have a job interview tomorrow for Coca-Cola industry.
Is that in Smith County? Oh. Doing what?
I was a forklift operator at Target Warehouse. So
All right, Mr. Jackson, there's a lot of things you gotta get going on or you're not gonna expire time. You're looking at 2 to 10 in prison if you don't get on the ball. 2 to 10, that's a long time. How old are you?
19.
19. 19 years old. already looking at a prison sentence. You have to grow up quick. Most 19-year-olds shouldn't have to be worried about going to prison. But this is the situation you find yourself in because of your actions. So you're gonna have to grow up quick, you're gonna get a job, you're gonna maintain that job, you're gonna take care of all of these things that you're court ordered to do. Or you're gonna end up in prison or jail or both. Okay? So this has got to be primary priority number one. You don't want to go to jail, do you? No. You don't want to go to prison, do you? This should keep you up at night. This should keep you up at night. Worried about, am I going to get a job? Am I going to be able to pay my probation fee? Am I going to be able to do my community service? You should be more worried about this than you should be, what am I going to eat tomorrow? What am I going to wear tomorrow? What kind of fun am I going to have tomorrow? All of that should be way, way in the back. All of this should be in the very front. Because that's the only way that you're going to comply and avoid prison. I'm telling you. I don't want to see you go to prison over stuff like community service and not paying and not doing drug classes. You went on probation. That was part of the deal. You had these things to do. It doesn't mean you just go over there and not do anything and avoid prison. It means you're serving your sentence in the community. And part of that sentence is you have to do these things. And you're on until April of 2025. If you don't get these things done, they file a motion to revoke. And we come back in here and we're not talking about, okay, let's reset you. How much can you pay? How much can you do? It's how much time you're going to spend in prison because you didn't do what you're supposed to do. Okay. So I'm going to reset you to May 9th. And this is what I've got to have out of you, Jaquavian. You've got to pay $95 to probation. You have to pay $140 to the court for your court fees. And you're going to have to figure out how to do 20 hours of community service. If you're not working, community service ought to be easy because you've got time. Every day that you're not working, you could go volunteer somewhere and knock out 10 hours. That's pretty easy. 2 days a month and you're done. 2 10-hour days, 4 5-hour days, 5 4-hour days. You do the math. It's pretty easy. Okay, so if you're not working, I can understand the money. I don't understand the community service. Get a friend to drop you off somewhere, set that up, handle it. There's a lot of churches, nonprofits, food banks that could use a young man like you. Okay, so there's no reason not to get that done. But you're going to need to do 20 hours of community service. And you're going to have to do that every month from now until March of 2025. If you want to be off probation, if you want to get me out of your life, I hope that you do. Then that's what you'd have to do every month. Every month, $95 for probation, $140 to the court for your fees, and 20 hours of community service. That's like your life. That's part of your life every month. Just like if you had a car payment, just like if you had a house payment. If you don't pay your car, what happens? They take the car back. You don't pay for your house, what happens? Eviction. What happens if you don't pay for your community service? You lose your community service. It gets taken away from you, just like all those other things. Okay? So this has got to be your life. All right? All right. Any questions? And you've got to enroll in that drug offender class. Okay? So you're going to have to, I hope that job interview goes well tomorrow. Go in there, sell yourself, get the job. If you get it, be thankful for it, work hard at it, do what you have to do a great job. Work your way up, hold that job down, use that job to keep yourself out of prison. Okay? All right. Come up here and sign over here. She's going to bring this to you. Sign this. Y'all need to David Pesnell, CR 21-183, Sanctions Court. All right, Mr. Pesnell. All right, Mr. Pesnell, I guess before we go through your stuff, I wanna get a UA today, okay? Let's come over here, have a seat. Mr. Waddell will be with you, or take it where you want. Mr. Silva and Mr. Huggins. It's Mr. Oh, I didn't say yes. Mr. Huggins. Is Mr. Silva here? Go ahead and have a seat over here. I'm gonna have you U8 also. Deck 2 or 3. So is Derek Silva not here? Derek James Silva. Mr. Manning. Do you want some? Yes. All right, so Mr. Mitchell, he has a warrant. So that's gonna take care of us. We won't be having sanctions court on him today. Is he the only other one? So Derek Silva didn't show. So is it just Mr. Pesnell that'll? Alan Wines. All right, Miss Dowling Wise. Come on up. This is cause number CR 23-11. State versus Samantha Elizabeth Dowling Wise. We're set today for you to hire a status on you to hire an attorney. Have you hired an attorney? Miss?
But I found out that not calling that I forgot to tell him his name on it.
Who's his?
My work. So we were gonna go out, but
All right, let's see. Board's going to reset Ms. Wise for. I'm gonna allow you to fill out the affidavit of indigency. I'm gonna reset you for arraignment. April 25th. Ms. Wise, have you signed your conditions of pretrial release? With Mr. Waddell? Yeah, I'm waiting for some paperwork real quick. All right, so Ms. Wise, I'm resetting you to April 25th. You'll need to fill out the new paperwork. Ms. Abraham will tell you to go out of town. I don't see any restriction on you being able to not leave the state. So I don't see any conditions on any of these conditions of pretrial release. All right, so Ms. Wise, I'm gonna have you sign your conditions of pretrial release today. I see that you signed some with back in October. But I'm going to amend them. Have you sign them today. And so I had you drug tested, so I know you're positive for methamphetamine. I know you're positive for THC, but because the magistrate put your conditions for pretrial release on there, didn't check off the box to have you drug tested, I'm not gonna hold your bond insufficient today. But I'm gonna make a note that you showed up in my court positive for meth, and positive for THC. I'm probably gonna drug test you every time you come to court. And if you continue to test hot, then you're gonna go back to jail. All right, so what I want you to do, go with Ms. Abraham. She's gonna take you back. She's gonna give you the paperwork to fill out for court appointed attorney and the new conditions of pretrial release. Save the money. Yeah, sure. Jeremy Hester. No, I'm gonna do bond insufficient. No response. All right, let the record reflect the cause number CR 21-291, State versus Jeremy Wayne Hester. Mr. Hester was not present in court as ordered at 9 a.m. He's not present at this time, which is approximately 11 a.m. The court has had his name called loudly distinctly 3 times with no response. The court notes for the record that surety A Springer bail bond attempted to file or did file a 1716 request yesterday. The court took that into consideration, did not assign or deny that. The court hereby finds that Mr. Hester did not appear in court as ordered. The court is going to find that his bail is insufficient at this time. The court's going to revoke his bail and institute new bail in the amount of $100,000. All right, Mr. President. Excellent. I just marked it. All right, Mr. Pesnell, this is sanctions court hearing. This is cause number CR 21-183. Let's see, I show. They're reporting to me that you're not complying with your counseling. That you're using vulgar language and humor within the classes that you attend. You also did not appear at court, at sanctions court last time.
Sanctions court, I still have not no record in the proceeding.
Hang on, let me see if I can figure out the notice issue. All right, well, let's address the report of the vulgar language and the humor.
In classes when you're talking and say. That's- Crowd, because now why say that. All class where I thought it would be. In a private setting. That would be, it wasn't now. Said. Concept, name, concept that word. We'll have to apologize to him. I'm never upset at him. Yeah. My personality. Try to be.
Does he set forth ground rules on how the counseling and the classes are supposed to go, what's expected, how you're supposed to conduct yourself, decorum? And you believe that you're following that to a T?
I'm following it now. Thank you, funny cracks. In the beginning, leave on a serious level. And so I did. And why it's following me, I mean, I don't know, I might change. Guys. I might change.
Do you understand that you're in the class for the reason? The class is not there for you. You're there for the class. You understand that? You understand that if you get kicked out of that class, that's gonna pose a problem for you. You gotta have that class. And you gotta get through it. Otherwise, it's non-compliance. And if that non-compliance is because you want to be the class clown, or you want to be funny, or you want to cuss, or you want to be disruptive, if you're getting his attention in a negative way, you're gonna be kicked out of that class. And it's not like we're gonna go to the Rolodex and find out where you're gonna be a better fit. Everybody fits in this courtroom. Everybody fits. This is where you're gonna end up. And you can cuss and laugh and joke away your liberty.
I wish I would have had, I wish that. Wait, it myself. That. Have to talk about it. I have to. Yeah, I may change.
So this is your defense. You go to him, you apologize for your behavior, let him know that you didn't mean to offend him, you didn't mean to be disruptive, and that whatever he needs you to be compliant, that you're going to do that, and that you want to change what he reports to your probation officer. It doesn't mean that you have to change who you are. Doesn't mean that. It just means you have to change your behavior. There's nothing wrong with being humorous. It's nothing fun with being witty, lighthearted. Nothing wrong with that. But there's a time, there's a place. Any of these people in here would tell you that I like to laugh, I like to have a good time, I like to have fun. That's my personality. You probably don't see that side of me. because there's a time and the place. And my time and place in here is not to be witty, humorous. Hang on, I'm talking right now. Right now you need to change your behavior. You're steadily thinking about what you're going to say as I'm talking instead of actively listening to me. I can just imagine you're doing it right now. You're doing it right now. Your mouth is moving the whole time I'm talking, David. The whole time I'm talking. That means that in your mind, you're sitting there thinking, I'm just going to say this. I want to say that. And that when you're thinking, it means you're not listening. All right. I'm telling you, there's a time and there's a place. And I'm a certain way in here because this is the time and a place and a job. Outside of this, it's going to be a lot different. When you're in that classroom, you need to be a lot different. You need to be the guy that he is commending. You need to be the guy that's a leader, or you just need to sit down, shut up, be quiet, and get through it and do what you got to do. I see that you updated your address with the court. Did you update your address with your probation officer? You did. I'm showing that you filed the updated address 22. That's why he didn't get notice of sanctions court. Here's his new address right here. Are you still at 705 Richard Street? Where are you at now? Let's see. So the sanctions court notice went out January 20th of 23 is when around that date it got mailed. It got mailed to 8175 Highway 80 in Grants Lane. What are you? So who is 8175? Don't know. Is this a house? Is this a? Okay. 8176 Highway 80. This is address. All right, so I'm gonna let you slide on the not being here because it appears that would be a mistake on our side. Okay. And I'm going to trust that you're going to go back to the counselor. You're going to square up man to man. You're going to take care of that. All right, so I'm gonna reset you to May 9th. I'm gonna have you come back and I'm gonna ask the probation department to give me an update with your counselor to see how you're acting. And you had that discussion with them. And then we're gonna figure out this methamphetamine problem you got. Has been a year. That's a problem, David. You know you're looking at 2 to 20, right? 2 to 20. It's a long time. And you don't get sentenced. You don't get sentenced and the amount of sentence you get based on if you relapse. You get sentenced based on the crime that you plead guilty to committing. Your probation gets revoked for the relapse. So if I'm to consider how long you go to prison, I'm looking back to the aggravated assault deadly weapon that you plead guilty to. That's what your sentence will be based on. That revocation will be based on whether you're violating. If you don't want to get revoked, if you've got a problem, it appears you do, you need to figure out how to fix that. You get with your probation officer. You need to convince them that you're worthy of keeping on community supervision. Special Well, when you hit bottom, there's only one place to go. You can either stay there, you can, like you said, pick yourself up and go. All right, Ms. Abraham's gonna bring you this notice of setting, sign that. And we'll see you back on May 9th. And we'll resume at 1:30. You're welcome. You're welcome. Free to go. Hey, Tyler, did you and John need to talk about this or something different? That's, Michael David Murphy, this judge. Okay.
It was just explaining in case you needed it, Judge.
Do I need it?
Jonathan filed a motion
We'll see y'all at 1:30. All right, that concludes the criminal docket. We will be in recess until 1:30. Criminal docket will start up on Zoom.